So what did the Supreme Court actually think of the two cases brought before them regarding Section 230 of the Communications Decency Act, which for you and me has real-world implications? It seems that every time we talk about a D.C.-based subject, we think of it as something happening over there or for them, or what does it really matter to us? Well, whether or not you get to post online matters a great deal. Whether or not this section, these 26 words that created the internet, that gave these platforms the space to be able to try things and do things without being held liable, and then how they, in our view, abused that trust with censorship. Are these cases now brought before the Supreme Court going to lead to more censorship? Is it going to leave Section 230 the way it is? Or has the actual bringing of the cases, is that enough to see changes in these social media companies and other tech companies that has a real effect on our lives? Tony Katz today. It is good to be with you. James Czerniawski joins me right now, senior policy analyst at Americans for Prosperity. Full disclosure, I do work with Americans for Prosperity here in the state of Indiana. I get paid by Americans for Prosperity. They sponsor my video series. I do work with them. It's very important always to know where somebody stands with these things. There's nothing uglier, in my view, than somebody who doesn't share where the connections are. But I don't know James, and I got this email that James is talking about these things today because he writes about Section 230. He writes about antitrust. He writes about consumer data privacy, cybersecurity, and technology and innovation issues. And, of course, James, you were watching what the Supreme Court was doing here in these two cases, in this Gonzalez versus Google case, which is the first case they heard, and then Twitter versus is it Tamina or Tomnet? I can never get it correct. A brief breakdown of what these two cases were, and then case by case, what did you hear from the court and how they may be viewing this?
Yeah, thanks for having me. And I think that these cases are substantial for two different, entirely separate reasons. They can impact how companies go and handle content on the internet and how they present it to users. So with the first case, which is Gonzalez v. Google, this is a question about Section 230 and whether or not Google could be held liable for recommendations of content to users on their platform. So think like YouTube in this instance, who is the direct person being, sued in this case. They're going and recommending to you when you go into their homepage or when you're watching videos on the sidebar, different videos for you to look at. So I'm a big New York Giants fan. I go and I watch some New York Giants content on YouTube. It'll go and start recommending me different kinds of New York Giants content that I could possibly be interested in consuming. That's a good thing, honestly. I think that's great for the end user. But what happened in this particular case is that there was a terrorist attack in Paris. Unfortunately, somebody was killed, and an ISIS recruitment video was popped up within YouTube in and of itself. And because of that, the family is suing, saying that, YouTube was basically posting ISIS, recruitment videos and enabling them to recruit people that way, and they should be held liable. Now, that's the first case. The second case is Twitter, Tomna v. Twitter, and that is a different question. It's not necessarily 230. This is focused on an interpretation of the Anti-Terrorism Act, which is a very specific piece of law in terms of figuring out whether or not an individual, whether that be a company or a person, had materially and substantially helped a terrorist in some kind of way as he was about to go and commit a terrorist act. So these are two very different cases, but they both have pretty big implications.
Now, let me take a moment here, James. Let me make sure I've got everybody caught up. I love the detail. Talking to James Czerniawski, senior policy analyst at Americans for Prosperity. This Google versus Gonzalez case, Gonzalez versus Google, get it wrong. This is fascinating because Section 230 is about protecting someone like Google from content that is put upon their platform. But the lawsuit alleges regarding this terrorist attack and someone dying, a family member dying, that it was the algorithm of Google on YouTube that led to this video being seen, and the algorithm is not protected by Section 230. How did that get explained to the justices, and how did the justices react to that tidbit of differentiation?
To be honest, I think it was a struggle to explain this kind of theory because it's definitely more academic in nature. And the lawyer that was representing the clients in this case that were bringing the suit was trying to distinguish that when Google goes and uses its algorithm to make a recommendation, that somehow transforms it away from user-generated content speech into something that is more purely, demonstrative of Google's speech, and therefore that's why Google should be liable. Now, whether or not that's convincing or not is a separate argument to be had, but that was the kind of drive that they were going with there. As to how SCOTUS received it, I think that there was a lot of confusion insofar as that, I believe it was Justice Kagan so kindly, had no problem admitting these are not the 9 greatest experts on the internet that were sitting on the Supreme Court. So I think that there were some limitations there, and they were trying to understand what the theory was in terms of how the law would be applied. And I think that in this case, the plaintiffs were struggling with really connecting the dots well, or trying to get, taking the olive branches that the Supreme Court was giving them in terms of getting like a remand to go and review a different question. I think it was kind of telling ultimately, because if Brett Kavanaugh at one point was talking about how if we were to go and adopt this kind of interpretation of the law, that it would ultimately defeat Section 230, and that doesn't seemingly make sense. Because we're saying that the whole point of Section 230 is that we're not going to hold platforms liable for third-party content, which makes sense for lots of reasons. But if we go and we put in this carve-out here, it seems to defeat the law in and of itself, that we're going to be encouraging a lot of tort lawsuits as a result of that. So I think that it's an uphill battle, but we don't know for sure what the outcome will be for some time. But it's definitely something that we'll continue to monitor.
Now, what's fascinating when you talk about the court there, because it's a very honest position from them to say we're not the 9 greatest experts on the internet, but also it very much falls into what I believe is Chief Justice John Roberts' philosophy. And not that I agree with it at all times, and not that I think that he's even followed it at all times, but the idea that maybe this isn't for us to decide, this is for Congress to decide. The Communications Decency Act was 1996, and if we're going to now get into the parsing of these things, this shouldn't be about the court making some level of dictate. This should really be about Congress going back and changing the legislation. Has there been any appetite that you've seen from Congress to take a look at these cases brought before the court and say to themselves, yeah, we got to be the people who handle this one?
Yeah, there's certainly been plenty of appetite when it comes to Section 230 and Congress and wanting to do some kind of action there. The question is what is the right proposal? And I think the biggest hang-up has been that right now Democrats and Republicans are diametrically opposite in terms of what they want to seek out of such legislation that would go and impact Section 230. If you were looking at what the average Democrat proposal looks at, it's trying to find more ways to take down more content from the internet. If you're looking at the average Republican proposal, it's trying to find more ways to keep speech up on the internet. And the problem is that both approaches, at least with the proposals that I've currently seen out there, unfortunately do violate the First Amendment of the Constitution. And if it can't pass that sniff test, it's going to surely get challenged if Congress were to pass any of these kinds of proposals. So I think that, Congress is trying to figure out what is the right approach here in terms of tackling some of the issues that we might be seeing when it comes to these big technology companies and how they're operating online.
James Czerniawski joins us, senior policy analyst at Americans for Prosperity. I ask you now to take a bit of crystal ball. Of course, we're not going to get the actual decision on these cases until the summer. But very often, there are people who will stare at the court, watch every member of the court, look at body language. Once again, Clarence Thomas is asking questions, which he didn't do while Scalia was alive at all. And now he asks questions, and he did so again here. From what you observed and from what the observers you trust observe, where do they think the court is on 230? Are they going to leave it alone, or are they going to make some kind of claim that there is a culpability that these tech companies have?
Yeah, that's a great question. I think that obviously Justice Thomas has been, certainly on the cheerleading, round over there, try to get a Section 230 case before the court. And then, we finally get one. And I think that this one failed to kind of live up to the hype for what his expectations were in terms of the facts of the case and what was out there. Because even Justice Thomas, I think, in some of his lines of questions, seemed a little sympathetic to, the underlying situation with Google insofar as just that, like, well, hold on, wait, if we're going and, taking action here because of this, couldn't that lead to more lawsuits? Couldn't that go and have negative implications on speech? And you even had, like, Justice Alito offering some commentary on that line. So I think that the justices will probably ultimately side with Google and not hold them liable, but there might be some kind of thing that's buried in the opinion that might be trying to draw out an outline for what they think might be amenable in terms of where you could see reforms go in the eyes of the court, right? Usually it's within the opinions that you can go and try to construct where the justices' minds are at in terms of what they think would be able to survive scrutiny at the court. So it'll be interesting to see what happens. I think that the person who is most likely going to side with the people bringing this suit is, interestingly enough, Ketanji Brown Jackson. She seemingly did not understand Section 230 all that well, and seemed pretty critical often during her exchanges with the lawyers. So I imagine she might be one of the people that dissents in such a decision. But again, too early to tell exactly what it looks like. But my guess is I wouldn't be surprised if it was something like a 7-2 or even possibly an 8-1 kind of ruling with a whole host of opinions that get attached as a result.
Regardless of the ruling, because we have to assume that 230 stays, as I think that's what you're saying, 230 will remain intact.
Yes.
The idea of bringing these cases forward anyway, does this change how tech views the posting of content? The argument being that just the bringing of these cases will give big tech more breathing room to engage more censorship, because after all, they don't want to be held liable if this happens or that happens, so they're going to take extra precautions, be extra careful. Is there a fear that that's going to take place? Is that a grounded fear in your view?
I think it's a grounded view. It's a grounded view, in my opinion, because if Google were to be found liable. Reason being is that right now, recommendations are a core function of the internet. The internet is built on a series of recommendations. Whether you're searching for something on Google, you're listening for something on Spotify, you are going and looking for a Yelp review, all these recommendations are things that would be opened up to potential liability if something were to go wrong here in this case. And that's just too big of a stage, when we're looking at economic impacts and those kinds of downstream effects. I think that, that's why the court is probably going to want to go and say, hey, Congress, this is not for the court to decide here. This is for you to decide. I don't think it's an invalid claim to say, hey, look, if this goes wrong, censorship increases quite exponentially, because if a company has to choose between taking exposure to liability for hosting our views, our expression, or not having that liability at all, they're going to opt for the version that doesn't expose them to liability. And that's just where it's at. That means that it'll be harder for us to go and find new people, new voices, hear new kinds of perspectives on things. That's one of the greatest things that Section 230 brought out. Discovering new things on the internet, because recommendations all of a sudden are going to be a very dangerous game for a company to play with.
James Czerniawski, Americans for Prosperity, Senior Policy Analyst. Full disclosure, I do work with Americans for Prosperity in the state of Indiana. I am sponsored by Americans for Prosperity in video and in other things, speaking engagements that I do. It's important to always be full disclosure. James, I appreciate you taking the time to be with us. I have got more coming up. I'm Tony Katz.